Hello everyone. So today me and my team gonna talk about Malaysian legal system. And we all gonna focus on court hierarchy. So before we start our presentation, we would like to introduce ourselves first. My name is Muhammad Nakib Alham bin Muhammad Nasir, and this is all my team members, which is Wan Nurul Izzati binti Sheikh Wan Yusri, Muhammad Naim bin Ruslan, Muhammad Daniel Haikal bin Muhammad Fazil, and Shahmi Haziq bin Shafri. First, introduction of court hierarchy. Why court hierarchy built for? The court system are built in a hierarchical system in order to facilitate the hearing of cases and any appeals against them. Beyond having a hierarchy, the courts are also divided into courts of first instance and appellate courts. Courts of first instance are where matters are heard for the first time. The Malaysian courts of justice are made up of the superior courts and the subordinate courts. Next, subordinate courts. What is subordinate courts? On the criminal side, in ascending order of hierarchy, are first-class judicial magistrate court, chief judicial magistrate court. Certain matters on criminal side or civil side cannot be tried by a court lesser than a district court. This is the example courts that under a subordinate courts, which is magistrates courts, sessions courts, and others courts. Superior courts. What is superior courts? A superior court is a court of general competence which typically has unlimited jurisdiction with regard to civil and criminal legal cases. A superior court is a superior in relation to a court with limited jurisdiction, see lower court, which is restricted to civil cases involving monetary amounts with a specific limit, or criminal cases involving offences of a less serious nature. This is the example courts that under a superior court, which is high courts, federal courts, and also court of appeal. That's all for me. Thank you.
Hi, Assalamualaikum. My name is Shahmi Haziq bin Shafri. Today I want to present about magistrate courts. Magistrate courts have two, which is civil matters and criminal matters. Civil matters. A first-class magistrate should have jurisdiction to try all civil proceedings and case when the amount in dispute of the value of the subject matter does not exceed 100,000. According to the subordinate courts, SCT 2010, a second magistrate monetary jurisdiction has been increased to 10,000. Next, the magistrate also have the authority to deal with small claims case where the value of the dispute or subject matters is less than 5,000. A key distinction of a minor claims procedure is that parties cannot be represented by a lawyer unless Order 93 Rule 7 of the Rules of Court 2012 requires it. Criminal matters. A first-class magistrate may impose any sentence allowed by law, up to and include 5 years in prison and Rm 10,000 fine, wiping up to 12 stroke, or any combination of the above sentence. This is accordance with Section 87 of the SCA. A second-class magistrate shall only have jurisdiction to try offence for which the maximum terms of imprisonment specified by law does not exceed 12 months imprisonment of either description of or which are punishable solely by fine under Section 88 of the SCA. If a second-class magistrate believes they if a conviction occurs, the power of punishment that he has are instrument. He should take the required step to have the matter adjourned for trial by first-class magistrate.
The Court of Session, commonly referred to as Sessions Court, has been established by the state government for every session, division, and it is presided over by a session court judge. The judge is appointed by the higher court of the state. Keep in mind that there is only one session court in each division at different places. Also, it comes within the purview of a specific number of judges. Section 225 to 237 of the Code of Criminal Procedure deal with the procedure in trials before a court of session. What are the functions of session court? Upon hearing the submission and evidence presented from both sides, the session court judge can decide any of the following: whether to discharge the accused if sufficient grounds are not established, Section 277, or frame charge if there is adequate ground for presuming that the said accused committed an offence that is exclusive, triable by the session court as per Section 228.
Hello, my name is Muhammad Naim Rusan and this is the jurisdiction of the High Court. What is High Court? High Court was established under Court of Judicature Act 1964. There are two High Courts, which are High Court of Malaya and High Court of Sabah and Sarawak. High Court have three jurisdictions, which are criminal, civil, and appellate jurisdiction. Cases before High Court will be determined and decided by the High Court judges and judicial commissioners respectively. For now, there are 50 High Court judges and 49 judicial commissioners. For the first jurisdiction is criminal jurisdiction. High Court shall have jurisdiction to try all offences committed within its local jurisdiction and on the high seas on board of any ship or any aircraft registered in Malaysia. This court may pass all sentence allowed by law, including death penalty. For the second jurisdiction, which is civil jurisdiction, High Court may try all civil matters but generally confines itself to matters which the session court has no jurisdiction. There are no limits as to amount of claim. This court shall have jurisdiction to try all civil proceedings where first the cause of action arose, the defendant or one several defendants resides or has his place of business, the facts on which the proceedings are based exist or are alleged to have occurred, any land the ownership of which is disputed is situated. The third jurisdiction is appellate jurisdiction. The appellate criminal jurisdiction of the High Court shall consist of the hearing appeals from subordinate courts, according to any law for the time being in force within the territorial jurisdiction of High Court. The appellate civil jurisdiction of the High Court shall consist of the hearing of appeals from subordinate courts as hereinafter provided. This is subject to any other written law. No appeal shall lie to the High Court from decision of any subordinate court in any civil matters. And this is the other jurisdiction of High Court, which is revisionary jurisdiction. The High Court may exercise powers of revision in respect of criminal proceedings and matter from subordinate courts. For the civil, the High Court may exercise powers of revision in respect of the civil matters from the subordinate courts. Thank you.
My name is Muhammad Dani Haikal bin Muhammad Fazil Ashraf. Today, I will be presenting to you the Court of Appeal. The Court of Appeal is the second highest court in the hierarchy below the Federal Court. The court is headed by the President of the Court of Appeal and constitutes up to 10 Court of Appeal judges. Every proceeding in the Court of Appeal shall be heard and determined by 3 judges or such a greater uneven number of judges. The Court of Appeal is an appellate court of the judiciary system in Malaysia and has jurisdiction to hear appeals against any higher court decisions relating to criminal matters. In civil matters, also the Court of Appeals has jurisdictions to hear and determine. No appeal shall be brought to the Court of Appeal in the following cases. The first is if the amount or value of the subject matter of the claim is less than 250,000 ringgit, except with the leave of the court. The second is the judgment or order is made by consent of parties. The third is the judgment relates to cause only. Lastly is where by virtue of any written law the judgment or order of the High Court is final. Federal Court. The Federal Court of Malaysia is the highest judicial authority and the final court of appeal in Malaysia. Its decisions bind all the courts below. The Federal Court consists of a president style as the Chief Justice, formerly called the Lord President, the President of the Court of Appeal, the two Chief Judges of the High Court in Malaya and Sabah and Sarawak, and presently 6 Federal Court judges. The Federal Court is heard by 3 judges or such a greater uneven number of judges as the Chief Justice may determine in some particular cases. The Federal Court has the exclusive jurisdictions to determine, which is all civil and criminal appeals from the Court of Appeal. In civil appeals, a litigant may appeal on a point of law the rejection or admission of evidence in lower court. In criminal cases, an appeal may be made against acquittal or conviction or against sentence on a point of law or fact. Moreover, any constitutional questions which have arisen in the proceedings of the High Court but refer to the Federal Court for a decision.